Good morning to the court. My name is
All
Sean
right.
Wodarczyk. I'd like to reserve 90 seconds.
How much?
90 seconds.
90 seconds, a minute and a half. Very good. Thank you. Welcome.
May I begin?
Yes, please.
Yes. Good morning to the court. I represent Ned Hansen, who's in the courtroom with me today. Mr. Hansen was a claimant in a probate proceeding below involving the decedent, Mr. Masulla. This appeal arises primarily from the dismissal of Mr. Hansen's claim, as well as a denial of an attempt to amend that claim. The specific relief we're asking for is that the court reverse the trial court on both orders. With that said, let me talk a little bit about the legal background here, and then I'll get to the facts and how those two intersect. As I'm sure the court is familiar with, when a probate claim is made, that is governed by 32301 in the Tennessee Code. It sets out a fairly simple procedure for making a claim against an estate. You file your claim in the manner required by 32307. That sets out some requirements of the actual form of the claim. If you are proceeding on a written instrument, you need a copy of the instrument. If you are proceeding on an open account, like an open account of credit, you need an itemized statement. For everything else, you need an affidavit. That affidavit has certain formal requirements, saying it's a just and valid obligation. From there, once you've filed that, assuming you've done it timely, if one of the other interested parties, the estate, an heir, etc., has a problem with your claim, they think it's not valid, for example, it's not a debt that's owed, they can file an exception. That is allowed under 32314. From there, the clerk has to set a date for a hearing on that exception. You get 15 days warning from the clerk. I want to remind you of that statute, 32315. We're going to come back to it in a minute. From there, the trial court is supposed to try the exceptions under 32315 as well. That trial may be by the bench, it may be by the jury, depending on what is requested in the claim or any amendments thereto. So what happened here? Mr. Hansen filed a claim. It is not based on a written instrument. It is not on an open account of credit. He did verify it as necessary under the statute. There is an itemization that he provided of various things he asserts that he is owed. That wasn't necessary, but he did provide it as part of the claim. From there, exceptions were filed. And then something odd happened. A motion to dismiss was filed, one by the heirs and one by the estate. Motions to dismiss generally, and this was the motion to dismiss under Rule 12.026. That is odd because this court has previously held that motions to dismiss, or that claims are not a pleading governed by the rule of civil procedure. We see that in a couple of cases. One is the state of Green versus Carthage, which is cited in our brief. The other is Etheridge versus the state of Etheridge, which is cited in the appellee's brief. Both of them say that a claim is not considered a pleading governed by the rules of civil procedure. And there's a reason for that. The idea behind the claim process is that you make your claim, they make their exception, you have a brief trial, judge gets to the merits real quick, right? In this case, the probate court did not follow that procedure in the statute. Instead, it went and granted this motion to dismiss that is foreign to this area of practice. That was error. What should have happened is there should have been a trial.
I agree with you that a motion to dismiss is foreign to claims against an estate. I agree with you that claims against an estate start out as very simple procedures, and they're exempt from the rules of civil procedure because many times the claimant is pro se and they just want to deal with it. But once the issues are framed and it becomes evident that the case may be complex, the rules of civil procedure clearly apply.
Well, that is not something that is shown in our case law in terms of how this should have been adjudicated. Could they apply in the sense that discovery would be warranted? Certainly. But in terms of whether a Rule 12.026 motion...
Well, why would the rules of civil procedure apply for discovery but not for a motion to dismiss?
Well, given that the court has previously held that, quote, a claim has never been considered a pleading governed by the rules of civil procedure, end quote, I presume that what the court means...
Then that means the rules of discovery don't apply either.
If you want to go there, you may, Your Honor. I'm not here to argue about discovery.
You're paddling up a pretty strong current in my view, but go ahead.
That's fair. Here is the point. When this court reviews a 12.026 motion to dismiss on appeal, it is looking for the sufficiency of the complaint, right? We're looking at the Rule 8 pleading standard is what we're looking at, is whether the complaint is formally, appropriate, right? This court has never quite embraced that standard for claims in the probate context. And even if this court had, in this case, Mr. Hansen had done all the things that were necessary to tee up an appropriate claim.
Counsel, what's the theory under which he's entitled to any of this? I mean, I walk in, I provide some receipts, and how does that indicate that the estate owes anything?
Right. So the theory is that it's personal services and goods, right? And I would point you to a couple of different cases that have arisen here before. One is Wilson versus Halfley. That's 226 Southwest 2nd, 308 from 1949. It's a Tennessee Supreme Court case. That's cited in the appellee's brief. In that case, there was a request for personal services from a neighbor to another neighbor because the other neighbors were old and advanced of age. And the Supreme Court said that was a valid claim and it should be paid. So there is precedent for this exact type of claim. It's ultimately an unjust enrichment claim, if you're asking about what it really is. Now, whether it is meritorious or not is a question for trial on the exception, not a question for a non-trial hearing. And that is the point, that Mr. Hansen, whether he can succeed or not at trial, is a question for a later day. A trial should have occurred, and that this probate court prejudged the merits of this matter. Does that answer your question, Your Honor?
It's helpful for understanding the basis on which your client thinks he's entitled.
Exactly. I point you to another case that's in re estate of Sadler, which is in our brief. That's an unjust enrichment case where the trial court did the right thing. It tried the case. Now, it ultimately found that there was no entitlement, but it had the trial, which is the point, is that litigants are entitled to have their claims heard by the probate court appropriately. And that did not occur here. Speaking of which, I note that the appellees in their brief tried to characterize the proceedings below as a trial. It was not. You may remember a few minutes ago that I bookmarked a certain statute that deals with the clerk giving notice of a trial of the exceptions. There is no notice of a trial of the exceptions in this case for December 18, 2024. There's nothing there. That is a requirement under the statute if you're going to have the exceptions
heard. So what
heard.
should we do with that? Does that mean the claimant creditor wins because the clerk failed to do something?
No, not at all.
So what do we do with that fact?
What I'm addressing is an argument that is in the response. The response argues that a trial really did occur, and that's just not true.
It was disposed of on a Rule 12 motion.
Exactly.
So there's no trial.
Exactly.
Now, wasn't there a trial in another case?
There was in a Chancery Court proceeding. There was a trial.
How many times does somebody get to go back to a different court to try to get a different answer?
Well, that would depend on what actually happened in a given court. In the Chancery Court proceeding, the only trial was a quiet title trial between the heirs and Mr. Hansen about who owns some land. That is not a trial of the claim between Mr. Hansen and the estate. As such, there is no going back here. And I note that the trial court, in this case the probate court to be specific, found that his claim was barred as a supposed collateral attack. That was error, and I can get into the merits of that in a moment if you want me to. It looks like Your Honor does. Error for a couple of reasons. First, a collateral attack is when you ask one court to go ahead and disregard another court's order to find that it's essentially invalid, right? Whether, and there's a slight nuance between direct attack and collateral attack that we don't need to get into here, but that is the gist of it. There is absolutely nothing about Mr. Hansen's claim here that would require the probate court to say what the Chancery Court did was wrong. All the Chancery Court did was say that land passed outside of probate and it is owned by the heirs. That's got no effect on whether the estate owes Mr. Hansen any money one way or the other. Also, in a collateral attack, you file your suit asking a court to go ahead and set aside someone else's order. That wasn't done here. You won't find it in the record. And in fact, the claim was filed before the Chancery Court proceeding, so when filed, it wasn't a collateral attack either. So respectfully, that was error by the trial court. I also note that as long as we're talking about trial court errors in its rationale, there were three other bases for the trial court's granting of this motion to dismiss. One was that supposedly the statute of frauds applied here, and that it barred everything. Respectfully, that would be a decision that would need to be made at trial. If a contract if a contract was alleged or brought forth that would fall within the statute, then maybe that would be an appropriate ruling. But on the face of the claim, there's nothing there that says there is a oral contract that falls within the statute of frauds. There's,
Well, if that's not the case, what is the basis of your client's claim?
as I said, it's an unjust enrichment claim.
Well, doesn't,
An unjust enrichment does not require the statute of frauds. The appellees agree with that in their brief. Go ahead, Your Honor.
what was the basis of the services that your client allegedly rendered that made the decedent obligated?
Right. So he provided a couple things. One was material goods and improvements to land on the decedent's property. The other was personal services.
Doesn't that imply, does it require at least some type of implied contract?
It may, and implied contracts generally are not subject to the
Well,
statute
what
of
basis
frauds.
would your client have other than that?
You would characterize it as an implied contract or unjust enrichment, essentially would be the two.
Well, aren't they essentially the same?
Yes, I don't mean to dicker with Your Honor. There's, I guess, a minor nuance.
So we've
yeah.
got an implied contract.
Correct. And implied contracts by definition are not written.
They're not what?
Implied contracts by definition are not written. As such, the statute of frauds
But
says it.
you're saying, I hear you, you're saying the statute of frauds can't apply to an implied contract.
Not an implied contract under these circumstances. If it was an implied contract for the sale of land.
Under these circumstances, okay, all right.
Yeah.
'Cause
Yeah.
I heard you make a carte blanche statement.
No, I don't mean that. If it was for the sale of land or for sale of goods over $500 or one of the other things that's within the statute of frauds, then yes.
But if you're arguably rendering services for $1 million, it doesn't apply.
Correct. If I went to my law firm and I didn't have a written employment agreement and I worked there for 2 years and they paid me a substantial sum of money, the statute of frauds would not bar my claim, even though it is at that point an implied contract. It's the same concept. So similarly, the trial court also erred, I see my time is running short here, on the statute of limitations issue. The trial court dismissed the entire claim on the basis of the statute of limitations. It never referenced what statute. Certainly contract or unjust enrichment claims are subject to a 6-year statute. The face of the claim very much shows that there are claims being made within that 6-year period. The trial court just frankly, I think, threw the whole thing out without really considering that. The last thing is the trial court found that the claim was, quote, unsubstantiated. I'm not sure what that means in terms of the trial court's decision. I note that the formal requirements of the statute, that there be an affidavit that set out some certain language, that was met. So in terms of substantiation that was required by the statute, that was met. And also, that's a trial issue. If a litigant comes into court and you have the trial you're supposed to have and they can't prove their case, they may lose at that point, but that requires a trial, which is not what occurred here. And so that's a kind of a prejudgment. I'll also note, and I've got about 30 seconds here, there was a amendment that was requested. That all comes down to whether this case, which was stayed, whether a stay was lifted or not. There was 8 days left for Mr. Hansen's time to amend his claim when the case was stayed. This trial court never lifted the stay. Its order does not contain the language we would typically see in a self-lifting order where it says, without further order of this court, this shall be lifted. And the time between when the appellees filed their last motion to dismiss in the trial court, which kind of kicked things off again, to the date of Mr. Hansen's response and amendment was 6 days. So his amendment should have been received. I've run short on time.
Wasn't the basis that it was futile? Wasn't the trial court's basis for that ruling that the amendment would be futile?
I did not read it that way. I read it, and there's some language in the order about this, that it was untimely. I believe that the trial court did not think there was extraordinary circumstances that would have justified a delay, but I think that is sort of missing the point, which is that if the case was stayed, time wasn't running.
All right, thank you. We'll hear from you on rebuttal.
Thank you, Your Honor.
Good morning.
Morning. Good Good morning. As I listened to the argument this morning and some of the back and forth, one thing I would like to start off with and note is the three judges that are before me, y'all are the first three to hear this argument. And there's three particular points in which y'all are the first to hear. Is with respect to the hearing, there was never a request to continue or an allegation of Judge Hagan, hey, I don't think we had a fair hearing. I've got some witnesses I'd like to call. There was no comment or anything about that. We had a date, we showed up for a hearing, and on that hearing date, there was also a motion to dismiss, or several motions to dismiss. And I think it's important that if I'm the attorney representing Mr. Hansen, and I show up and I expect to just have the motion to dismiss heard, and then we get into the other part, I would bring that before the court. Judge, this is kind of limited to just this. And there was none of that. And so the aspect of not having a hearing, you are the first judges to actually hear that. Judge Hagan never had the opportunity to say, yes, if you would like to present a witness, let's reset another date. And in the order, and the court speaks through the order, part of that order that's continuously ignored is there was no witnesses or testimony present to be presented. And I think that's important there was just nothing that occurred at the hearing date that they were prepared to do.
But usually a motion to dismiss hearing does not contemplate live testimony. It's usually on what is in the complaint, or in this case, the claim.
I agree, yes, sir. And there was a notice of hearing on my motion to dismiss with respect to that. But
wasn't that what happened that day, or was it set for trial? I'm trying to appreciate the...
So in full candor, the notice of hearing was on my motion to dismiss. The clerk did not issue an additional notice to say the trial is going to be heard. However, it was I believe the understanding of everybody that there was going to be a hearing that day. We were prepared to have a hearing on everything regarding the creditor's claim that day.
Normally, if I was representing the plaintiff and I was faced with a motion to dismiss and a hearing was set on the motion to dismiss, I would not show up at that hearing prepared to have an evidentiary trial.
In any other civil case, I certainly agree with you.
Why is this an exception?
I think because of the efficiency of how probate court was or is designed, that it was the understanding, maybe not part of the record.
Well, what was the basis of the trial court's ruling? Was it a basis on a motion to dismiss, or that the evidence was insufficient?
Both.
Okay. All right.
And with respect to the hearing, the first time I heard it was in the brief filed by Mr. Hansen, counsel. And so that's why I think, a motion to continue, or even a motion to reconsider while it's still in the trial court, to allow Judge Hagan the opportunity to say, okay, if you'd like to present some witnesses, you may do so. Or file an affidavit and do an offer of proof. That way we would at least know what they are alleging factually as part of their claim.
Counsel, you've heard the arguments today, or the first time these are being advanced. What was the basis of contestation over the motion to dismiss then? What was the battleground there between the parties in this case?
Well, the motion
with regard to the motion to dismiss here.
Yeah, so there's a couple different grounds. It was statute of limitations, statute of fraud, collateral attack. I think those are the main ones that come to mind at the moment. So that was the basis of the motions.
And what was the objection to your argument? That was what was fought out before the trial court then? And you're essentially saying that we're in a whole different realm of what's being argued here. What was being argued there?
Oh, I understand what you're saying now. So as far as the argument that day, it was those motions to dismiss. It was their motion to amend or modify the claim, and I believe that was the substance of what was discussed that day at the trial or the hearing.
Now, it's my understanding the trial court ruled that this was a collateral attack. The other case was a quiet title proceeding. Who owns the real estate? Is that right?
That was part of it.
Right, okay.
Yeah, so Mr. Hansen initially filed a complaint for an implied partnership, a constructive trust, unjust enrichment, and there might have been a fourth claim. I believe there's 4 claims all total.
Based in part on the services he rendered and the equipment and materials that he provided.
Correct. So the attachment to the probate claim is the very exact proof that was attached and alleged in the complaint in Chancery Court. It is identical facts, identical claim for money, just different legal theories in a different court. So
All right, and the final order in that case is in our record.
I believe so, yes.
And those claims were non-suited though, right? Before the trial in Chancery?
The morning of, yes, sir.
Okay.
Yeah. And just, I do believe the chronological events in this case are very important, and I actually do a timeline in my brief because initially this was filed in probate court, which is the claim we're here about today. And the clerk issued a notice, like, you know, they typically do in proper, and the day before they filed an expedited motion to stay the probate claim, and they filed a Chancery Court petition for the implied partnership and everything. So the probate court stayed this case right here so we could litigate the case in Chancery Court. And so that's when the litigation goes on for 2 years. We have interrogatories, depositions.
But what was ultimately tried in Chancery was just the quiet title, right? That's the only thing that was actually tried in Chancery Court.
Correct, yes, sir.
Okay.
No, I will note, we're more than 1 year past a final judgment from their non-suit. So I do believe we have a judgment with respect to that matter as well. But as far as what was actually tried, yes, the only thing was the quiet title.
Walk me through that one. So if they filed in probate, and then you're saying filed the same thing in Chancery, but then non-suited in Chancery, why does that eliminate the basis of their filing in probate? And how does the probate filing go away? I mean, it stayed, and how is that eliminating the probate action?
Yeah. So whenever they non-suited the Chancery Court matter, I believe this was a non-suit with prejudice, and that probably something they would dispute too, that they could not then refile it. But let's just say for argument's sake they could. They would have had to refile their case within 1 year according to the non-suit with prejudice, and we are more than 1 year beyond that now. And so that claim now is on the merits. That they would not be able to refile the claim in Chancery Court because they're more than 1 year beyond their voluntary non-suit. And so why should they be able to litigate a claim there, non-suit it, more than a year past, and then try to relitigate the same claim in probate court?
Which suit was the first to be commenced?
Probate court.
Okay.
Probate court, shortly thereafter, Chancery Court. 2 years down the road, Chancery Court is non-suited. And after Chancery Court, they then file a lawsuit based on the same facts in federal court. And then federal court has dismissed administratively that lawsuit.
Is that in the record?
I'm sorry?
Is that part of this record?
The citation to the federal court is, yes, sir.
Thank you.
I don't think the pleadings necessarily are part of this record, but I do make a notation to the federal citation to it. And so once that was administratively solved, we got back to the probate litigation, and then that's when we had this hearing. So, and that's why I honestly believe this is not about the merits of it. This is about a delay. You know, he's been on this property during this period of time, using this property, and so the longer this court process can drag out, the more he can have access to the property. And so that's why we're here.
How is this a collateral attack upon the quiet title action? What's the attack upon the court made a determination who owns the property, and how is this a collateral attack upon that?
Yeah, so I don't think it's actually a collateral attack on the quiet title. I think their non-suit became then a judgment. It is a judgment. If we only have that one case to look at, they could not then come back and relitigate that. So it might not be a judgment in the sense of judge found this and granted our favor or granted in their favor, but it is now a final judgment on the merits. And that's why I think it's a collateral attack, because if he was, say, hypothetically to go back to probate court and be successful, now we have two courts in which an opposite situation could occur, because he can go back to Chancery Court.
But in the probate court, is he claiming a partial title to the real estate, or is he seeking a monetary judgment against the estate?
Well, his claim actually says a little bit of both. So it has that he's seeking 2.1 million roughly, and then later in it, it says that he's seeking the land based on services that he performed. And I think part of that rationale is that Mr. Hansen said that Leo Masulla was going to do a trust, and the trust was going to put all the land in it, and that Mr. Hansen and his children were going to be the beneficiaries of that. And so there is a little bit of a blended argument that they've made in the different pleadings with respect to what they're actually requesting.
So that issue arguably would constitute a collateral attack if he's still trying to claim an interest to real estate in which the Chancery Court has already quieted title in the heirs.
Yes, sir.
Okay.
The second thing that the first time a judge had the opportunity to hear and process is whether or not the rules of civil procedure apply to probate claims. And that argument was never presented. He did file a response to some of my motions in the trial court. That position was never taken in the trial court. There was never any argument with respect to that. And the first time, again, I've heard about that was in the Court of Appeals. And so respectfully, I believe that they've waived that issue as well. The third thing is regarding the expiration. If you look at the order as to the stay, it says that the probate claim is stayed pending a resolution in the Chancery Court matter. And I read that to say, as soon as the Chancery Court resolution is resolved, whether that by trial or dismissal or whatever it may be, then probate court then is reactivated. So it is self-initiating. I don't have to go back to probate court and ask for the stay to be lifted and tell them, hey, this is resolved. And so, again, that argument was never made to the Chancery Court, or I'm sorry, to the probate court. That was the first time that we've heard about that in the appellant's brief. Staying on that very topic, I believe a time frame to that is also important. If you look at the time frame, the judgment in the Chancery Court was September 13th. And so 30 days pass, then we're at October 13th. So we now have a final order from Chancery Court. And if they say their 30 days then starts, it would have started, and I'm just taking their argument for facts, it would have then started October 13th, which then you have until November 13th to file an amended claim. Well, they didn't file a request to do so until December 17th. So even if you take part of their position as true, they are still untimely in filing a petition to amend their claim. And the only roundabout way to do that is to then show that there's some type of extraordinary circumstances in which I'm entitled to an extension to do so beyond that. And there was no proof. There was nothing presented that gave the probate court any basis to do so. And so respectfully, I believe it was very correctly denied with respect to the stay.
Tim, tell me about the statute of frauds issue and what was the basis there?
Yes, sir. So the statute of frauds is, as I mentioned earlier, part of their claim is the eventual obtaining the property. And just for kind of the court's reference, you know, we're dealing with 30 acres, and then on the back half of 30 acres, Ned Hansen owns that 30 acres. So we have 30 acres Leo Masulla road frontage. On the back half, we have 30 acres of Ned Hansen. And so as part of his claim is to either basically financially force the estate into doing so, or to get the real property so he could have collective 60 acres. And so there's no contract back and forth between the parties that, hey, if I provide services for your farm, then I'm going to then give this farm to you. And I believe that's exactly what the statute of frauds deals with, is if I'm going to buy your property, whether it's through money or trade, then we have to have a contract to do so. And you would have to take that contract and then apply it to, or attach it to your claim in probate court. And there just wasn't. I mean, what was attached was credit card bills. So, and then an itemization from Mr. Hansen as far as what those detail out.
Is the claim of title to the real estate separate from the factual basis of the services and equipment and products that Mr. Henson delivered?
I guess I'd say no. Well, no, I'd correct that. Yes, partially. In Chancery Court, part of what his theory was is that they did this trust and that the trust was basically a valid executed trust, even though it was unexecuted. But as far as the claims for farm work and services, stuff like that, I believe that's really just related to money.
So the claim of this trust agreement and why the decedent, Mr. Masulla, would arguably agree to convey the property to Mr. Henson was not based upon the services rendered?
Partially.
Partially, okay. All right, okay. All right, all right,
Thank you.
thank you very much.
Thank you all.
A rebuttal?
Yes. If your honors want to write down record number 23, that is the actual claim that is made in this case. It's going to look like this, and it shows exactly what the probate claim is and what it's not. It says personal care of Leo Masulla, 2009 to 2022, farm management and improvement services, 2009 to 2022. It does not say title to the property. So we just heard some argument here that supposedly Mr. Hanson was trying to make a probate claim to title to the property. That is not part of the claim. It says so right here.
And your client did not amend the claim. There was a motion, but there was never an official filing of an amended complaint.
Yes, there was a motion to amend it. That motion was denied the very next day. We've appealed from that. That motion was timely because the stay was still in effect. With respect to, if you look at our brief, you'll see that there's examples of what self-terminating.
In fairness, didn't the stay go away when the Chancery Court case was pending? If it was no longer pending, if final judgment had been entered?
I understand the temptation to say, well, it says when it's resolved, that must mean that it lifted. Courts generally don't do things that way, for one.
Wow.
Part two, in terms of giving Mr. Hanson sufficient notice that the stay was lifted, you would think that there would be some specifics about what the actual resolution is. Is that a final judgment? Is that the point where appeal has run? Is that the point where all of the claims that he had asserted have been
It's his
adjudicated?
duty to know that you count 30 days from the entry of the judgment in a case in which he was a party. So,
Fair enough.
anyway, all right.
My time has run short. I did want to address one more thing. if
It's
Your Honor.
technically out, but you can sum up.
Yes. There was comments about the 1 year issue a minute ago. I think counsel has mistaken the savings statute and the effect of the statute of limitations for the way judgment actually works. If your honors have any questions for me, I'm happy to answer them.
All right, thank you very much. Thank you both for your arguments.
Oh, and may it please the court, I spilled a little water over there. If the clerk has a paper towel, I would love to mop up.